the Public Policy and Regulatory Affairs team at Shardul Amarchand. We work on a number of technology, regulatory, and policy issues, including the intermediary guidelines that we'll be discussing today. Since this has been out for a while, I assume there's some amount of familiarity with the intermediary guidelines. So I will be doing a quick overview of the main questions that have been raised and the concerns that have been raised by industry stakeholders, at least. And if there are any questions, please feel free to post them. The other thing I just want to flag at the beginning is from when the previous, the intermediary guidelines were notified last year, there have been a number of cases challenging the rules. And we see that many of those issues are recurring now with the proposed amendments as well. So I will try and flag them as they go.
Puneet, just a request, if you could speak slowly, some people take some time to understand.
Sure. So to start off with, the first sort of issue, first concern is with rules 3.1a and 3.1b of the intermediary guidelines. Now 3.1a says that the intermediaries should ensure compliance of their user policies, and 3.1b states that users should not cause users to disseminate prohibited information. To do a quick recap on 3.1a and b, these are due diligence requirements, which require that the intermediary publish their user policies and ensure that users are informed of the rules and the sort of community guidelines that intermediaries might have in place. Now, the proposed amendments are a slight departure from the existing duty. And with many of the changes that have been proposed, there's first of all a lack of clarity or a clear standard on what the meaning of many of the terms is. So I'll start off with ensure compliance with user policies. Now, while it would follow logically that if you have policies in place, you do, like intermediaries do their best to ensure compliance with those policies, but to put them down in the manner of a legal obligation in a delegated legislation such as the intermediary guidelines suggests that the regulators want the government to play a more active, want the intermediaries to play a more active role, be it in terms of editorial control or in terms of proactively monitoring content. Now, the problem with that is that this goes against the meaning of Section 79 and as Section 79 of the IT Act and is recognized in Shreya Singhal, where the whole notion of an intermediary that is present in the statute and was recognized by the Supreme Court was that intermediaries do not interfere with the content, that they merely host third-party content. So the extent to which the proposed amendments now want intermediaries to ensure compliance and cause their users to not disseminate such prohibited information is not clear. And if the intent is for the intermediaries to start playing a more active role, this is likely to be found to be in violation of Shreya Singhal and the scheme of the IT Act and Section 79. And the other thing is, as I'd mentioned, a lot of intermediaries now, and also because of the due diligence requirements,
recording in progress,
have existing mechanisms. You may have all seen that when there is any content that violates the 3.1 requirements or violates the IT Act or other requirements imposed, you do get notices that there are pre-existing mechanisms. So the incremental obligation that would now be exerted on intermediaries is what is not clear through these amendments. Moving on, the second change or the set of changes, I've clubbed them together in a way that they all sort of make sense, is the obligation on intermediaries to ensure accessibility, to meet the reasonable expectation of due diligence, privacy, and transparency, and to respect fundamental rights of citizens. I'll take these one by one. Now, again, the meaning of what ensuring user accessibility is not clear, because accessibility could have different meanings under different statutes. And again, we must keep it in mind that this is important because this is appearing as something that intermediaries must comply with. It appears in a delegated legislation that they have to comply with. And it's a legal obligation that they have to ensure user accessibility. Now, this could mean many different things. For instance, in India, we speak many different languages. So would this mean that people who speak different languages should be able to access these platforms? Does it mean that, for instance, people with disabilities, as there is already a scheme to ensure better accessibility for them under the People with Disabilities Act, does it mean that platforms should be more accessible to differently abled people? Or is there any other notion of accessibility that the regulators want? Again, this is not really clear. So I think we would need a little more clarity from the regulators on what the meaning of ensuring user accessibility is. The second question here is on meeting the reasonable expectation of due diligence, privacy, and transparency. Again, the obligation on intermediaries is already clear in terms of the requirements already present under Rule 3 of the intermediary guidelines. Under the SPDI rules, you would see that every intermediary now has a privacy policy in place. They have to appoint a grievance officer. They also have to sort of deal with complaints as and when they come, and this duty already exists. So if they are sort of setting out a reasonable expectation standard, what does that mean? Now, the term reasonable expectation also exists, for instance, in case law, both outside India and in India. It's also been recognized, for instance, in Puttaswamy and other privacy judgments. But to have an intermediary implement that, you can't rely on principles. You would need sort of clearer guidelines on what that exactly means. That at this point is not exactly clear. Again, the same issue as I'd mentioned earlier, what is the incremental change that they're asking for in terms of meeting the reasonable expectation of privacy, due diligence, and transparency? Now, the final thing, and this one is a bit loaded, and this one I think requires a lot more discussion, because this has been an issue that has come up not just in India, but in other jurisdictions. One of the proposed change is for intermediaries to respect the fundamental rights of citizens. The sort of concern with this is, as per the Indian Constitution under Article 12, while every citizen has a fundamental right, it's understood generally in India that this right only exists against the state, that is the government, which is why when you have to enforce a fundamental right, you go to court, or you file a case, or you exercise these rights only against the government. There is limited jurisprudence in India in terms of enforcing these rights against private bodies. Not that it doesn't exist, but the jurisprudence is still evolving. For instance, by comparison, if you looked at some other jurisdictions like the US or UK, where there are sort of human rights acts, or if you look at Civil Rights Act, which is a landmark legislation in the US, through those laws, you can enforce your civil rights or your fundamental rights against private citizens, against private bodies. We do not have that kind of jurisprudence yet in India. So while this is still evolving, it is again not clear what the duty is on the intermediary themselves to respect fundamental rights of its citizens. And the problem with the changes in under 3A, B, M, and N, all of them going back to the scheme of Section 79, going back to what Shreya Singhal says, the role of an intermediary that's been recognized and sort of enacted in the IT Act is that they are supposed to be, for a lack of a better term, dumb pipes. They're supposed to host content that third parties publish. And their role is essentially to follow orders issued by the government and not interfere with the content. So if you're placing increasing obligations on them to respect privacy, respect fundamental rights and citizens, that has to be done in a manner where it balances against their existing sort of requirement to only host third-party content and not interfere with the content. So getting back to this fundamental rights issue, that would again become the question of what are the extent of fundamental rights. As you've seen, this is not a settled question by any stretch. People keep going to court again and again to enforce these rights. So while this sort of framework is evolving, it's not clear why this duty exists on an intermediary. Moving on, the other issue, and this is a bit more, and maybe some of the more technically minded people will be able to help with this during the course of our conversation today, is on the obligation on intermediaries to address concerns within 72 hours and within 15 days. 72 hours is to take down any content that's within Rule 3. This is generally considered as prohibited content. There are 10 categories of content, which includes, sexually explicit material, hate speech, inaccurate information, defamation, and things like that. Now, the timeline for that has been reduced to 72 hours. And if any users sort of disseminating this information, if there's a request to sort of block their account or to take down their account, the time to sort of respond to that has also been reduced to 15 days. Now, on the 72 hours question of blocking content, the problem there is there is already an obligation to sort of share information with law enforcement agencies within 72 hours. And that's a compressed timeline because you're often trying to respond to a crime or respond to a national security situation. Now, if you extend that 72 hours timeline for all sorts of content, one, it would be very impractical because it would be hard to sort of comply with that timeline given the vast amount of content that's uploaded on any platform. Second, there'll possibly be a move to sort of use as much automated decision-making as possible. And the results of that, as many of you might know, will be mixed at best. And third, to sort of use this 72-hour timeline, the government has justified it as saying that in the preamble to the amendment, that content on the internet tends to be viral. So it's best to sort of proactively catch this content and take it down within 72 hours of being notified. While that is true to an extent, but not all content on the internet becomes viral, that you need sort of different standards for different types of content. Again, with this change and most other changes, with a little bit of more guidance from the government or a little bit of more explanation of what the reason for the changes and how this has to be enacted, it would be more helpful. The second change is in Rule 41C, where it suggests that SSMIs, which are significant social media intermediaries, which have a user base of larger than 50 lakh users, which have incremental sort of obligations under the intermediary guidelines, they also have to adhere to the timelines mentioned above. Again, the issue is that when you're dealing with such a large user base, to respond to complaints in such a short timeline, it would be much harder for SSMIs. On top of that, responding to within 72 hours, as I mentioned, becomes tricky in many situations. The final change that I will be discussing is the proposed amendment to Rule 3.3, where the amendments propose to establish a grievance appellate committee, where the way it would work is currently, if you have any problems, if you have any complaints with the way an intermediary has been administering content, for instance, of a social media company takes down your content and you want to complain, or if you think that there's some offensive complaint and you want to complain, you go to the grievance officer, and there is a process through which most intermediaries, as you would be aware, take action against such complaints. The proposal for a grievance appellate committee is to have an appellate body on top of the grievance officer that will deal with complaints against the grievance officer. Now, this is quite a common scheme that the government seems to be in favor of these days. You see, this is similar to the scheme that's been set up for OTTs in Part 3 of the intermediary guidelines. The proposed data protection bill, for instance, also has the sort of appellate mechanism. And, in some ways, this can be a useful mechanism. As you've seen with the OTT guidelines, we know at least that most stakeholders are happy with the way that is functioning. But it's not clear if that sort of a mechanism can work here very clearly, again, because intermediaries are different. They're not publishers the way publishers work under Part 3. They don't have control over all the information. So you can't exercise that sort of editorial, you can't expect them to exercise that sort of editorial content over the content. Second, the way the grievance appellate committee is supposed to function itself is not clear. And I'll take you back to Shreya Singhal here. One of the reasons Shreya Singhal upheld many of the provisions under sort of Section 69A, Section 79, was that the requirement was that the process for which content takedown was the requirement that due process of law be followed, which means that the procedure be laid out for how content would be taken down, and the law under which this is being done be clearly specified. Now, with the grievance appellate committee, currently, it's not clear what sort of powers the GAC would have or how this would be exercised. And as many of you would know, there's an increasing tendency in the recent past for many sort of government bodies to use Section 69A, which is a national security provision, to take down content. And again, that happens sort of through a process that is not very transparent, and the decisions taken there are not public, which is fair if it is a national security process. Now, the problem is that with the GAC, it seems that a lot of similar sort of ideas are being brought in terms of there not being clarity on how the GAC would function. Why there is a need for a government body to sit on top of the grievance officer is also not clear, because under Shreya Singhal, it's been clear that you need a court order to take down content. And as I discussed earlier, there's already significant obligations on intermediaries to take down harmful content. They do have community guidelines. So there are many avenues. So it's not clear why a GAC is necessary. On top of that, there is also a proposal to have multiple GACs. So for instance, again, this is a parallel that exists from Part 3 of the rules, where there are multiple self-regulatory organizations that act on behalf of different segments of the digital publisher, different segments of the digital publisher sector. Unfortunately, again, as I mentioned, intermediaries work differently. The role in the law is different. The way they function, even in the outside world, is different. So to have multiple GACs and to have sort of courts sit on top of them and to have a completely government body overseeing this, it's not entirely clear at this moment. And this is, again, something that sort of needs more discussion, possibly for the government to sort of revisit this. That's the end of my presentation.
Thank you, Puneet, for giving all of us an overview of this. So, as I mentioned earlier, we have, if you could stop your screen sharing, that would help. So what we would now be doing is, Puneet gave an overview, but we'd like to hear from our various stakeholders who are there in our panel on how they look at it, what are the concerns, what are the places which needs perhaps relook. So I would start with Aman because he's woken up pretty early. So Aman, what are your views on this particular amendment?
Thanks, Amrita, for the invite to participate here. And thanks, Puneet, for that wonderful presentation. Just very quick word of introduction. I'm Aman Taneja. I'm with Ikigai Law. We're a law and public policy firm with a sharp focus on tech and innovation, work with a number of clients in the larger sort of internet and intermediary space. I have concerns with these proposed amendments, even from the perspective of being a user, but I'll maybe try keeping it a little focused on how I see this impacting businesses in this space. Puneet's presentation is going to be a little tough to follow because I think many of the things I wanted to say might have already been covered. So I'll try maybe skipping over some of those. But of course, the first big point, of course, is how this kind of turns the logic of safe harbor protection, intermediary liability a little bit on its head by requiring essentially asking platforms to take a far more proactive role in this, right? So Puneet spoke about the sort of contradiction with how Shreya Singhal looked at the role of intermediaries. I would even go so far as saying that in a certain sense, the proposed amendments actually bring in inherent contradictions within the language of the rules itself. So one of the changes that came in with the 2021 rules was a sort of explicit recognition of the Good Samaritan exemption, right? So the 3(1)D, the third proviso, was added saying you can voluntarily take stuff down, and that won't be deemed as you exercising editorial control. But and that was a welcome move when we were looking at the scheme of the act. So you can go beyond just the court orders and legal takedown requests, but you as an intermediary, if you find things problematic, take it down. Good incentive to sort of make sure, address some of the concerns the government had, right? Like the virality of content, not necessarily always needing to wait for an order to take things down. But now you're essentially saying, actually, it's not voluntary. You have to always be proactively taking things down. So that's another one of those inherent contradictions that seems to have been introduced within these rules. And I mean, one of the interesting things is we've seen rules come out rather quickly, but again, when the new 3(1)D came out, one of the good things that we noticed was that under the first proviso, it was stated that that the government would be notifying a set of agencies which can issue takedown orders, right? And that notification is something we're still awaiting. It's not come out, which would have actually made things a lot easier for intermediaries in terms of deciding on the lawfulness of a takedown request. Something we're still awaiting and hope to see that come in as well, because if I recall correctly, at the stakeholder interaction, when these points will be being spoken about on, do you need to proactively take down content, or is it? And I think the messaging that came was, no, actually just respect orders for takedown. And if that's the case, I don't see why you necessarily need an amendment. 3(1)D is pretty clear already. It would actually just become a lot easier for compliance if there was already an established list of agencies who are entitled to send certain types of content takedown requests. So that's one point. The other larger point that I want to make is that although the framing of the press release and a lot of the conversation seems to be that this is targeted at social media intermediaries, in fact, the amendments to Section 3 mean that this applies to all sorts of intermediaries, right? And again, and why is that a problem? Because there are there's up and down the value chain. You have internet service providers are also intermediaries under the definition of intermediaries, cloud service providers as well. What are the obligations on those sort of businesses? Very unclear from this, yet there is an increased obligation, right? So what is that increased obligation on other intermediaries who are not social media platforms? So again, something which could be, and the rules have already created a separate category of social media intermediaries. So if the intention is to only target those, perhaps that would be a better way of trying to do this. The third point I wanted to touch about again is on this creation of a grievance appellate committee. and I think Puneet spoke a fair bit about this, but I mean, what this does, apart from the fact that it creates, an additional layer there, it's also separate to the court. So two things are going to be running in parallel. The possibility of contrary decisions also emerges from this. So that itself is a problem. It's not just that courts are sitting in appeal over these, they're running in parallel. So you have two parallel functioning going on. And it is essentially you're setting up it is a judicial tribunal in some sense. And I think it would be fair. They are going to be making judicial decisions. And I mean, establishing a tribunal, there is a fair amount of case law on what are the sort of things that need to go in if you are, vesting judicial functions to essentially an executive body in some sense. So because it goes to the root of separation of powers, we will see situations where it could be a government, account which has been deplatformed. Let's take that example, and then they will be sitting in appeal over that decision itself. So that there is a lack of sort of that separation of powers there. I mean, there is some sense to the point that it is, as an end user, sometimes a little difficult to be able to get your, if you've been locked out of an account, it is problematic sometimes to be able to get it reinstated, etc. Getting your day in court or feeling heard could be a challenge, but I don't know if this is the right way to introduce that change. I did also at some point try thinking through whether, consumer protection would be a better route for this. Interesting challenge that comes up there is because for most of these services we're not paying, might not really actually count as consumers and therefore can't take platforms to consumer court. But maybe that's something we want to look at from a different perspective and have a judicial mechanism in appeal, right? And not leave it to the executive to be making these decisions, because that also causes a fair deal of discomfort. And I think I think Puneet already spoke about, the fact that a lot of the language here is not entirely clear. As a business, I need clarity to be able to make the changes that I do. What are reasonable expectations of XYZ? What are these? How do I create accessibility? There is a lack of clarity around those things, and that's, I think, fairly important to be able to do business. And I think the fundamental challenge is with what we are seeing here is that because these changes are being brought in through rules, which are essentially what your due diligence obligations need to be in order to retain safe harbor, everything gets linked back to your safe harbor protection, right? So failure to do even something pretty minor can result in you losing safe harbor protection, which itself has fairly grave consequences. In case of a social media intermediary, there's potentially direct liability on your employees. And should that be the case if I acted on a legitimate takedown request, took something down, there's a disagreement on whether a request is valid or not, should that have that grave a consequence? And it's also perhaps the reason that the government is not feeling as though action is being taken quickly enough, right? Because whether or not you're entitled to safe harbor protection is not no one but a court in a case deciding on whether you are entitled to that protection from liability or not is actually going to be able to decide that. It's not, I don't think it's a switch which turns on and off, that you are today an intermediary and tomorrow you stop being an intermediary. I think you remain that. The question will always be whether, with respect to a particular piece of content, you are entitled to safe harbor protection or not. And it is because these rules are, using just the due diligence powers under Section 79 that, some of these challenges are being created. And the point I'm trying to make essentially is that there are alternate ways to incentivize or disincentivize, platforms deplatforming people or taking too long to encourage to make decisions. I don't know if this is the only route that you could do it. It could be through, other sorts of penalties like fines, etc., which might make a lot more sense than everything having to be decided on in terms of whether you continue to remain entitled to safe harbor or not. I think I'll pause there. I'm sure there's a bunch of other views that we're still going to hear, and happy to take questions as this goes along.
Right. Thanks, Aman. I think there's a question for you on the chat. If you could, in case you want to respond to it in the chat, that's fine. Else we will take it in the Q&A. It was about...
Can the adjudicating officer, and I think that's not a terrible idea. I don't think the adjudicating officer mechanism has actually ever been effectively used under the IT Act, even though those provisions have been there. I will maybe go back to that and see if I do recall that they have powers of a civil code, but again, I think it is if they're exercising the sort of judicial determination whether the qualifications, etc., are sufficient is a question. Maybe changes or amendments to the IT Act to allow for this is something that we can look at rather than bringing in these changes through rules.
Thanks, Aman. We will get you in, but now we go to Aishwarya. Though you are also a lawyer, but you also wear the academic hat. So we'd like to hear from you as to how you look at these amendments. You are muted, Aishwarya. No, we can't hear you. Would you like to try again? Else, what we can do, Aishwarya, is I'll bring in Sijo by the time if you want to restart your system for the audio. So Sijo, yeah, this is good.
Okay, great. Well, what is an online event without tech issues? I'm glad hopefully that's out of the way for the rest of this event. Thanks so much for inviting me to speak. I'm Aishwarya. I work at the Center for Communication Governance, which is an academic research center that's housed within the National Law University of Delhi. Puneet and Aman are hard acts to follow. Again, I think since these are not very, there are a limited number of changes that the amendments propose, I think we are going to be repeating ourselves a fair bit. Although I will say that I think we can all generally broadly agree that platform regulation is an area that globally regulators and other stakeholders are grappling with in various ways. So it's not necessarily like there are easy answers or even answers that's going to make everyone happy. There's always going to be trade-offs that we have to make. And so I appreciate the opportunity, one, to speak at events like this, and also two, that the government is holding public consultations, allowing us to submit comments in these areas, which are going to have lots of consequences for users, and specifically with this for speech online, right? That being said, there are some challenges with some of the recent regulations that we've seen. So partly with the 2021 guidelines as well, we can see that various high courts have stayed parts of the operation of the guidelines for a lot of the reasons that I think will also come up in some of the critique of these proposed amendments. I know this is something that both Aman and Puneet have spoken about, but I do want to point that one of the main, I will speak slower. One of the main issues I think with the amendment, with the proposed amendment is Rule 31A and 31B, which I think, like Aman and Puneet have both pointed out, strike at the core of what it means to be an intermediary itself and at the model of intermediary liability. Because essentially what the government is requiring intermediaries to follow right now is a strict liability standard. It's essentially saying that if you do not stop users from uploading certain kinds of content, then you can essentially lose safe harbor, right? So that is the consequence. So this is shifting the standard from the earlier existing one, which is protected by Shreya Singhal, which is that you're okay with a certain amount of unlawful content online as long as you comply with certain conditions, one of which is that you have to be relatively neutral and not have too much of a say on what sort of content is uploaded onto your platform. So essentially, by putting them in charge of what kind of content is uploaded onto their platform, it sort of makes them publishers, which is in direct conflict with what is required, their behavior that's required to have protection, right, from liability. So that's one thing. Another thing with respect to Section 31B, Rule 31B, is also that there are a very broad categories of content that intermediaries are required to prevent users from uploading, right? So one is that Shreya Singhal has looked at the analogous provision under the 2011 rules and has held that that has to be read down to mean the kind of speech that is restricted under Article 19.2. The government has not really changed the rules pursuant to Shreya Singhal, and we have pretty much the same language from that time. Again, I think it's we can agree that there are certain kinds of content that maybe you need to take down more expeditiously. So child sexual assault material, for example, is something that is easy to make an assessment of. The technology exists for you to catch this relatively quickly. And so if there are different categories of content, it makes sense. So for content like CSAM, it makes sense to have shorter timelines. Where there are other adjudications of what kind of speech is permissible, especially when you're preventing platforms from uploading content that is, for example, defamatory or offensive. It's not an easy assessment even for a court to make, and it takes usually a very long time. And so essentially, it doesn't make sense to have the same timelines, at least for removal of various kinds of content. I know I'm switching between the amendments a little bit. The 72-hour timeline that you'd have to address takedown requests. And so one is whether it is permissible, whether it makes sense, whether under the intermediary liability standard and Shreya Singhal and actual knowledge, whether it makes sense for intermediaries to be able to make these kind of assessments. And two is whether it makes sense to have the same kind of takedown processes and timelines for different kinds of content, right? Again, the risk with all of this is that there is a risk of overcompliance, which means that there is a risk of more content being taken down than otherwise would be, because that just makes more sense for intermediaries rather than risking losing safe harbor. The other part of this, I think, that again Puneet spoke about, which I won't spend too much time on, is just that 3.1 and N, it's very hard to critique those provisions because they are very vague. It's not really clear what you're expecting intermediaries to do. And again, the issue is that you're linking this to safe harbor, right? And so again, like, it's hard to even assess what those requirements would mean or what kind of obligations intermediaries would be required to follow. So it's a little unclear what the intention of the drafting was there. With the grievance appellate committee, so there's an interesting thing that this allows you to do. So one of the things is that, so now currently as things stand, for takedown requests, you're allowed to approach courts. So if you ask a platform to take down some content and they refuse to do that, then you can go to a court saying, make the platforms take down this content because it violates this specific law, right? Now, interestingly, what this allows you to do is also approach this grievance appellate committee for reinstatement requests in addition to takedown. So at this point, when you ask for reinstatement of either your account or of material or content online, that is something that is contractually governed between the platform and the user. You can't really approach a court asking for some speech to be allowed on the platform. You don't have a right to say something against a platform, right? And so what this does is it shifts that, because it allows the grievance appellate committee to make assessments of what kind of platform is allowed, what kind of information is allowed, and also allows them to reinstate certain kinds of platforms and certain kind of content. Now, again, in theory, you have appeal mechanisms to the courts, but again, it has not really been exercised with respect to reinstation requests, although you can still approach the court for takedown requests. The other kind of issues with having this kind of body is that at this point, it's unclear who exactly is going to staff these bodies. So that is one thing. But also, if it is going to be an executive body, then that is something that platforms are going to be cognizant of as they make their takedown requests, their takedown decisions, right? And so this increases the amount of oversight that you have over speech on platforms. And the fact that this is something that platforms who have specific, like even the larger platforms who have specific teams doing the struggle with, is the volume of user complaints. And so essentially there's nothing to suggest that there also wouldn't be a similar volume of users challenging various kinds of requests, because this, again, doesn't only apply to takedowns, it applies to various kinds of like decisions that platforms take. So it's unclear that the government will have the capacity to be able to deal with the volume. You're talking about millions of people, you're talking about a variety of platforms. It's unclear whether even the government will have the capacity to be able to make this adjudication, even though there's a best effort sort of language in a 30-day timeline. So both of these put together do indicate that this sort of mechanism will have a pretty significant impact on speech online. And also another thing that maybe is good to point out in this case is that the committee is not required to provide any kind of hearing to the users for either takedown or reinstatements or decisions. This is not, this is an obligation that actually even falls on intermediaries, and it's also something that's provided for under the blocking rules under Section 69. And so, again, not endorsing the formation of this committee or the fact that this is the way we sort of establish oversight over platform speech. But it's also important to build in those kind of safeguards when you think about speech decisions, is to introduce the sort of like natural justice principles, which requires both sides to be able to have a hearing before you make decisions, take down, especially on speech on platforms. So yeah, I'm gonna stop here and let the others speak as well.
Thanks so much, Aishwarya. So we will now have Sijo sharing his views. Sijo, you represent the industry body because they are the ones who actually have to comply to these norms or rule regulations. So how do you look at it, or how do your members look at it?
So thanks, Amrita. So in terms of sharing broad views, I think we are talking about the specifics of the draft amendments. In terms of, if I bring my thoughts onto this, we recently had a Minister of State, Rajesh Chandrasekhar, announce that the government is even looking at coming out with a new digital Markets Act, Digital India Act, so to speak. And the root of that, where he came with an argument, was that the present IT laws is a 22-year-old act, and a lot of those realities are not in tune with the present challenges and realities of platforms. And if you bring in that particular viewpoint, the same intermediate provision or the IT Act that we're talking about, 22 years before is around 2000s, right? I mean, even the iPhone was about 7 years away, right? App stores did not exist. 2005, 2006, we were just getting used to Facebook. So it was a different, time and age. And these platforms, the kind of influence some of these platforms or the social media intermediaries had on our everyday life, not just even business, right? Even on our everyday life, the impact that these platforms have and the sway that they have is very different at this point in time when we are in 2022. Does it require a rethink of some of the provisions? Probably yes. What would that mean? I think as a whole, the world is trying to figure it out. Aishwarya just acknowledged in her opening address as well, world over, regulators are looking in terms of how best to look at the right regulations for these platforms. So to that extent, if you look from a principle standpoint, do we have a problem of deplatforming across platforms, and a right way to address that? Yes. Does it require? So the number of instances we see where companies are getting delisted and their entire business also goes bust has been very high. Is there a need for a grievance redressal mechanism? Absolutely yes, because in instance of this disproportionate power some of these platforms enjoy, in the case of a delisting, the way to reinstate that, the process is very vague, and sometimes even the process is also very arbitrary. So given these particular, and from an accountability standpoint, given the massive influence some of these platforms have, do we look at bringing in some of accountability as well? From a principle standpoint, I would still argue yes, because we do find instances where some of the established principles, like the right to stay in business, is a constitutionally guaranteed norm for a private enterprise. But sometimes it does, or even the IP rights for that matter, it comes in conflict with the intermediate laws as well. So yes, there are constitutional norms in terms of jurisprudence, in terms of, let's say, private citizen versus public. I'm not a legal expert, so I'll defer to judgments here. But having said that, do we have a problem? Absolutely yes. So what I read from this particular amendments at the starting point is that government has sort of made it very clear that it is sort of stepping in terms of looking at solving this particular problem. The government is also sort of, if you look at some of the takeaways from the consultation that happened, is that the government, even from a municipality community point of view also, right, even that particular provision, the government even ended up saying that, hey, if the industry can actually bring together a self-regulatory guideline, whether there's due process being honored, that's all something government might be open to looking at. So I think the consultation process also progressing well, in that various stakeholders are conveying the concerns and taking the discussion forward. But is there a feeling, at least on the part of the government and some part of the business, that the intermediate platforms are not doing enough? Probably yes. Now, having said that, there are various things to balance. So yes, one of the parts that are missing from the amendment, and maybe that's something we would also like to clarify with the government, is that there was a distinction brought out for significant social media intermediaries. And in terms of some of the reporting requirements, that distinction doesn't seem to be coming through very clearly in the particular draft. So that's an area of clarification. And even if, let's say, there are a lot of parts of the appellate council and everything is very unclear, and people have already shared concern whether there's a right way to solve for that. Now, keeping that aside, even if in a situation where everything works well and the council does, the committee does come out with redressal relief for business or individuals, if I were to share a perspective here to the audience and everything, right? Even in such a scenario, will these platforms even comply to that, or will that again be challenged in courts, which has been the scenario that we're seeing again and again? Is also another concern I would also probably like to share. So in the larger scheme of things, not just the right, is that the right way to solve for it? But even if it does work out well, will it actually provide relief to business and consumers? It doesn't talk in sufficient detail. But these are some of the behaviors that we've been seeing again and again. Even, let's say, in one of our, if we have to share an experience of our own, we have pursuing a competition case as ADIF with Competition Commission of India. And we find a scenario where even the routine administrative orders of Competition Commission India are challenged and writ petitions by courts. So, which again sort of defeats the earlier purpose of creating a appellate body to solve for the issue in the first place. So these are some of the initial opening thoughts. From a problem standpoint, yes, there definitely are problems to be solved for, and some of the foundation principles probably have to be relooked. And the fact that these amendments are also triggering some discussions, I think is a welcome move. And the fact that the government is also not sort of shying away from these discussions also a starting point. I think as industry and stakeholders, all of us have our role to also play in terms of conveying our concerns and figuring out the right solution. If I were to sort of speak on behalf of some of the Indian companies also, right? Some of the social media intermediaries that we speak about, if we take a generic rule principle, as an intermediary, some of the foreign companies have huge resources and much more years of experience in terms of navigating this. But some of our nascent companies are in our country also, which might fall under the intermediate provisions, may not be equally on an equal footing to take care of some of these requirements. So how do we strike a balance? Obviously, it's going to be a challenge both for the industry, and I'm sure it will be for the government as well. And this is where I'll sort of leave some of my opening comments. My fellow speakers have spoken very in terms of specifics. So I'll just leave it at this point in time and come back later.
Right. Thanks a lot. Nikhil, I'd like to bring you in because you wear a civil society hat, but you represent the media community and you also own a business. So how do you look at, these rules?
Thanks, Amrita. I also was involved at some shape or form with the Shreya Singhal case. And so I come in with perhaps a historical understanding of safe harbor in India as well, which is where I'd start off by correcting my friend Sijo about one little aspect, because I couldn't help but notice that he said that this is an amendment to the 2000 Act. The fact is that the Act was amended in 2008, and we should never forget why that Act was amended, and it's important. Let's call this the Avnish Bajaj test. Sijo might know Avnish, he's now a VC, started Matrix Partners, but at that point in time, he was the founder of a company called Bazi.com, and he had been, and it was acquired by eBay India, which is no longer in existence. But Avnish was at that point in time still the head of eBay India. And there was a porn clip that was uploaded on eBay, and Avnish was arrested when he'd gone from Bombay to Delhi to assist Delhi police in figuring out who had uploaded that porn clip on his site. So let's call this the Avnish Bajaj test, so to speak, that would someone in an intermediary go to jail because of these amendments? Because that is the root cause because of which IT Act was amended in 2008, right? So let's call this the Avnish Bajaj test. And, so we should not forget this aspect of history. When you look at these amendments and where intermediaries are being asked to ensure compliance because, and cause users not to disseminate prohibited information, and the lawyers can help me out with this, would they lose safe harbor? And if they would lose safe harbor, then they would get that liability. And therefore, would Avnish Bajaj go to jail? Is the question to ask. My sense is he would go to jail. And so this fails when it comes to respecting the Shreya Singhal judgment, and this fails when it comes to respecting the intent of the amendment to the IT Act. And things have not changed as much since 2008. App stores were in existence in 2003, 2004 as well. Multiple independent app stores where you could download J2ME apps, CISO. And App Store, and the Apple App Store came out in, I think, 2006 when the iPhone launched. So app stores were still in existence. Platforms are still in existence. E-commerce companies were still in existence. Forums where content used to be published were also in existence. The lens that we need to look at these amendments is not a big tech social media lens. We need to look at it with an intermediary lens, which means SaaS companies, e-commerce companies, ISPs, cloud companies, email service providers. The list is endless, right? And we have grievances with all of them at some shape, in some shape or form. Do you want a government appellate committee? Because this particular clause, the amendment to Section 3 or Part 3 of the rules, applies to all intermediaries, all platforms, everyone, not just to big tech. So while these rules are being created with the objective of targeting big tech, I think to take a big tech lens to everything that we talk about in all of these rules is setting us up for trouble, because today they'll impact big tech, but tomorrow they'll impact Indian companies and they'll impact small ventures as well. So I think we need to recalibrate how we look at these rules from the perspective of who it impacts, and keep in mind the smaller players, because let's not forget, when the GDPR came out, a lot of small ad networks died out, right? So a Facebook or a YouTube or any significant social media intermediary may probably have the resources to try and address some of these issues, maybe do pre-censorship, which is what, if most of you might not remember, but we went after Kapil Sibal for recommending that in 2011. And this government is no different, because it's creating an environment of pre-censorship with these amendments. But this is going to impact the entire internet. What we are seeing over here is a form of power transfer taking place. So platforms, companies, etc., have the ability today to take suo motu action and perhaps remove spam or remove some kinds of users that they feel are not compliant with the way they operate. I can run, like I say quite often, I can run a Manchester United forum and kick out a Liverpool fan because I don't want that person engaging there. That's my prerogative as a private entity. Can we give the power to the government to overturn that situation if it wants to? The same thing is going to happen over here. You're shifting the power of regulating their own private space from the platform to the government. And so from a government perspective, it is essentially an accumulation of power. Now, the other thing to keep in mind is that they are not amending the IT Act to do this. They already have a series of a set of unconstitutional rules that came out last year with the IT rules. Now, this is yet another unconstitutional amendment that is coming here because it's ultra-virus to the IT Act. Section 79 is not an enforcement provision, it's a due diligence provision. You can't create a GAC under a due diligence provision, right? And so, I mean, lawyers can correct me on this, I'm not a lawyer, but this is at one level going to create an environment of extreme control where the speech that the government wants to leave on social media will remain. The speech that it wants to remove will get removed, because it can also order takedowns directly because of the IT rules and Section 69, which it seems to be doing quite frequently now. So this is essentially ruling over speech and all other activity on platforms through centralization of power. Platforms, the unfortunate thing that's happened since 2008 is that there is centralization of the internet because of the App Store ecosystem and the app ecosystem. But the way to address it is not to give the government more power, but to create an environment for decentralization. So let's not confuse objectives. Our objectives, Sijo, here might be, and I'm sorry I'm addressing you on this, but our objectives might be to create a fairer playing field through a decentralized and a situation or a market environment where platforms have less centralized power. But our approach should not be one which creates the ultimate power in the hands of the government, which has statutory ability. That's also not a fair market environment. I think going back to Shreya Singhal, going back to the case, one of the reasons why we went after Section 79, honestly, 66A was just it became a side. It started as a sideshow and it became the main thing. But the real focus at that time was Section 79. And the worry was that platforms were over complying with when it came to censorship. So the protections regarding actual knowledge were brought in by the Supreme Court in order to prevent this over censorship. So I would say that this is directly in violation of the Shreya Singhal judgment, of the intent behind the Shreya Singhal judgment, and apart from, of course, being in violation of the IT Act itself. I would say that one of the reasons why we are here today is because companies like Facebook, Google, Twitter, etc., have failed to sue the government. I know WhatsApp went to court regarding end-to-end encryption, but they have failed to sue the government to prevent the implementation of the IT rules that came out last year, which were in every shape and form unconstitutional. And it's because we let that unconstitutional law pass through, or those rules pass through, that the government has now, expanding the scope with doing this. So let's not fool ourselves. This is one expansion which is happening now. There will be another expansion which will happen later. You will see more and more layers of control coming in, just like we're seeing more layers of government control coming in e-commerce, in case of cybersecurity, cloud. So that over compliance is going to create a significant amount of regulatory burden on all intermediaries and all platforms and all internet businesses, which is why, I was in San Francisco last week, and there were 100 SaaS companies from India looking to flip to Delaware, right? Which is why at ETH Dubai in February March this year, there were hundreds of web, or maybe 80, 90 Indian Web3 companies that are looking to move to Dubai. So if you're talking about enabling an environment for entrepreneurship in the tech space here today, that is slowly going to become more and more difficult because all of these regulatory overhang that we're seeing. And then let's not look at just this policy. Look at all the policies that have come up in the last 2.5 years are going to make it an extremely difficult operating environment for all tech businesses. What's going to happen, because the GAC will not have the capacity to deal with all the grievances that will be escalated to it by consumers, is that it will start becoming selective and arbitrary in its approach of enforcement. Just like the Delhi police can act on a complaint or a tweet raised by a single account that had a single tweet and a single follower, and that subsequently got deleted, they've arbitrarily put someone in jail, right? In the same way, you will see the government acting arbitrarily because it doesn't have the capacity to deal with all the complaints, but it can take the ones that it chooses and serves its purpose. It is that arbitrariness that we need to avoid over here. More government committees, more sort of ruling by committee instead of a proper legal process is basically going to create an environment of uncertainty for businesses in this country, and is going to make it more and more difficult for them to operate. So, just going back to Avnish Bajaj, what will it take? Because my sense is, no matter what we say in these consultations going forward, even if we participate in these consultations, just like with the IT rules, when we had objected to so many of the provisions that were unconstitutional in the first consultation that took place there, the rules came out in pretty much the same shape and form because the government wanted it. The intent is very clear over here. Whatever the Minister of State might say in his speeches and try to soothe things up, the rules might probably end up being exactly the way they are right now. We can hope that they won't be, but the intent is clear. What will it take, right? My sense is that it will take someone like an Avnish Bajaj to go to jail before this goes to the Supreme Court, and some sort of amendments come in later on. Either that, or you'll have a situation where the government will finally try and do the job that it has been wanting to do, which is amend the IT Act and post facto legitimize the rules that we are looking at right now. So broadly, politically, from a zoomed out perspective, this is sort of what the shape that I'm seeing regulation take shape right now. By the way, just another couple of points in closing. Grievance redressal is the popular mechanism right now of creating regulation. We are seeing that with regulation of e-commerce companies. We are seeing that with the food delivery companies. We are seeing that here with the IT rules amendments. It's an easy forum to create instead of choosing the right forum, which is amendment to the IT Act. Secondly, just because Rajiv Chandrasekhar goes on and on about self-regulation, that doesn't mean that there won't be a GSC layer still available to the government to enforce what it wants to enforce. So while you may talk about self-regulation, you look at the way they have handled streaming services, which already had a self-regulatory mechanism in place. In fact, they had evolved that over a period of time. Still, because the government wanted more control, they created another layer of a government committee on top of it so that they could enforce their writ. So I'm sorry to sound very pessimistic about all of this, but I think the writing is on the wall over here. It's very, very clear which direction we are headed in. And this is my reading of the situation, just looking at it from a zoomed out perspective.
Right, thanks, Nikhil. There was a comment about an incident in the chat, and there was a query to all the panelists that in order to save their intermediary status, the platforms might start over complying and restrict 19(1)(a). Should monetary penalties on platforms be installed for wrongfully taken down content if proved by means of redressal? Anyone in the panel wants to take this up? It's in the chat. I will again repost. You can take it in the chat. And I believe Niyati from Ku wants to make a comment. Okay, Nikhil, yes, first you go ahead.
So, like I said, platforms will keep restricting speech because they will be afraid of one of their employees going to jail because of the way the laws are shaped. You look at the way Twitter is behaving now versus how it had behaved last year before the IT rules came into force. Today they've asked Twitter to censor content. Tomorrow, because of these rules, that remit can also be given to an ISP to censor content. It really doesn't compute for me, honestly, because how can you be an intermediary and still be asked to proactively monitor and proactively take down content? Because the intermediary is not supposed to have knowledge of what's going on. It's a conduit of sorts. So you're basically seeing a complete dismantling of safe harbor as it stands, and Avnish Bajaj will go to jail. In terms of monetary penalties for platforms, I mean, what's the point? How minor is it going to be for a platform to pay a penalty in India, for that, unless it's a smaller company which they will go after. So I would say that it depends on what the penalty is for. Platforms are in no shape to moderate content, so all of them are going to be liable here. I don't think any platform, Indian or international, can handle billions of messages and billions of videos going up if they're expected to take down content proactively. Sorry, that's what I had to say about this.
Right. Thanks, Nikhil. We'll take some comments from the audience. I can see Niyati, you can go first, and then I see Avik's hand. Then I'll bring in the speakers to share their comment.
Sure. Thank you so much, Amrita. And thank you so much, all the panelists, for an interesting discussion on this topic. From who, I'm Niyati, and I'll just, quickly wanted to share our perspective, on the whole thing. We are an indigenously built digital platform, and, that largely caters the users. We prioritize user interest. And in view of that, we really support the amendments, that have come in. And in fact, we support the, establishing of the grievance appellate committee, primarily because it is largely user-centric. It's a neutral committee whose decision will have precedent and binding value. It'll also, help result in more transparency for everyone, and will also perhaps, help intermediaries better structure, the policies and better understand what is expected of them. I thought I would just, put in our perspective in there. Thank you very much, Amrita.
Thanks a lot. Avik, you go next, and I think I saw Nilanjana's hand after that.
Yes, so I am from the Indian School of Business. Hi, Nikhil, how are you doing? Good. So I just want to, so when I saw these amendments, I felt nice about it. So yes, I think a lot of you might not like my comment. So I then reached out. I come from the tech background, working in tech, developing the solutions for the very long, several years, and now I have dabble a bit in the policy space. So I spoke to various people, looked at what the leading research in this area is doing, and I saw that finding out what sort of content is not a good content, or putting some tags on the content out of billions of content, is something where the research and where these things have been implemented about 10 years back. So the technology already exists. It's more of a will of these platforms to implement them and serve it to the people for their use. It's just want to take a few examples where they see that usability as an aspect will be hindered. We see Gmail handling billions of mails every day, and they very nicely categorize our mails into buckets of interest, which is a social media, which is coming from spam, which is not. And this technology has developed to a large extent. When we are seeing them, when they are serving ads, they, out of the thousands of ads, they are able to target those 2 or 3 ads which are very relevant to them. So I want to tell you that we are trying to have the discussion here where a team of people will be handling it. I think that's not the solution going forward in this age in 2022. It has to be technology based. The technology exists today, and the platforms today, there is no penalty on their part. I should not use the term penalty. Like, they have no responsibility if there is some wrong content on the platform. If there is good content, there is advertisement coming at it. Users are benefiting. The brand, their platform is benefiting. There's only an upside. I think this much of responsibility should definitely be there on the platform. That if there is some content, you tag the content. And whatever you think are the risky ones, you should put them for a manual check. Not 100% needs to have a manual check. Maybe only 1% of the content needs to go through a manual check. And there are developed technologies around it. Banks are doing it, insurance firms are doing it, all sort of organizations are doing it, and the technology exists. So why shouldn't this platform use it? So my comment will be from that perspective.
Thanks, Avik, for your comments. As in, when I look at it from an end user perspective, it is good that if my grievances are heard, my comments are heard, but I also fear that will the platform be overlooking what I'm doing? Sometimes if there is a gray area thing, they may want to take it down. So those are certain concerns. How do you balance this?
Those will definitely be there, Amrita. So when we do
that is something which I have in my mind. It's just that these are gray areas which needs to be looked at. But your point is noted.
I'll give you one example, is that when we swipe our cards, these intermediaries who are there, Visa and MasterCard, because if it's a fraudulent transaction, they have to bear that amount. They do a due diligence whether it's a fraudulent transaction or not. So they have all the technologies in place. There's nothing of that sort of liability for the platforms if some wrong content is posted. So if there will be a few misses, if there's a technology-based thing, but if something is in a risky zone, send it for manual intervention. And that's what I'm proposing.
Thanks for your comments, Avik. Nikhil, I see your hand, but Nilanjana had raised hers earlier, then I will bring you in. Nilanjana, over to you.
Thank you, Amrita. Hi, everyone. I'm Nilanjana from Cuts International. I'm a lawyer as well and work in the field of tech policy and research. Though I largely agree with what Avik was saying previously, I do want to point out that all of this confusion regarding not having proper grievance redressal methods and also the reference to Shreya Singhal that Nikhil was making, just wanted to state that Nikhil Shreya Singhal happened 10 years ago. The decision was out in 2015. Things have changed. Technology has developed further. And it is necessary to place some responsibility on social media platforms for content moderation. Saying that, I also recognize that law in India has the term intermediary very broadly defined. There needs to be a graded approach for compliance. There needs to be a graded approach for definition of various companies. The threshold that has been set for a SSMI is way too low for the digital nagriks that the press note has defined. There was a study that happened in Germany, which we had cited in our study for ease of doing digital business in India, that for a population of approximately 75 million digital population, they had a threshold of around 2 million. So that was some percentage, which was 5% of the whole digital population. The current threshold in India is 5 million, and we have a digital population of 865 million, which is way too high. So there needs to be another layer added to the definitions of all of these digital companies, and then probably we can expect that the company should or should not moderate data. That's from me. Thank you.
Thanks, Nilanjana. Just for everyone, we may have to extend it for another 10-15 minutes. Hope that's okay with you. I'll bring in Nikhil, then I'll go in the reverse manner. Nikhil, then Sijo, and then we have Aishwarya, Aman, and then Puneet. Nikhil, over to you.
Sorry, but I'm going to call bullshit on some of these technology-driven solution comments that I've just heard, because speech is a hard problem, right? And you have to look at speech. And I'm not talking a week about translating voice to text and then modulating it or using AI ML to understand the intent of speech. Speech is an extremely hard problem that even courts very often struggle with. And human content moderators struggle with it as well. So you have to, and while we may have moved on from Shreya Singhal, it might have been 10 years since Shreya Singhal was a principle-based judgment. And let's not forget that those principles remain true today as they did then. Platforms are accountable for the content that they take down, and users have to have the right to file a grievance about their content being taken down. But you also don't have to create an environment where platforms have to proactively monitor content and assume a kind of liability that will lead to the takedown of free speech as well. In order to protect our speech, it is also important to protect safe harbor and the platforms that enable that speech. Because otherwise, if you hand that power over to a government or even over to AI and algorithms, you will find that there is far greater censorship of legitimate speech than there is takedown of illegitimate speech. And the legality of that speech should be determined by courts. It is difficult to do this. Yes, Avik, there has to be a beginning of using technologies as an assistance. But the moment you bring a liability into it for a platform, they're going to start censoring because they don't, it's less problematic for them to censor than it is to not censor. And that's the environment that you're creating by doing this. Fundamentally, you don't want Avnish Bajaj to go to jail for what he had no control over. And you have to understand intermediary liability protections. Safe harbor is what enables the internet to function. You take away that protection, you put in liability, and this liability, by the way, under these rules, applies to everyone from an ISP to a Facebook or a Twitter. You take away safe harbor, you basically destroy the ability for you to ability for you to share your speech. The music labels for the longest time have been trying to go after ISPs for enabling piracy. It is safe harbor that protects ISPs and therefore prevents ISPs from snooping on our connections to see what we are downloading and what we are checking, and the liability becomes ours, right? Not theirs. No platform in today's day and age will survive the liability for all the content that is uploaded on it. Technology cannot take down all of that content. It cannot enable. It is simply impossible for speech and for video to be. So technology is to assist, and platforms are already using technology to assist. But please, without understanding Shreya Singhal, without understanding why we got Shreya Singhal, what happened beforehand, there was a cartoonist under 66A who was jailed by the West Bengal government. There were two girls at Palghar who were jailed because of a comment that they made when Bal Thackeray died. What did that girl say? Two girls, right? One said, "Why should there be a holiday when a politician dies?" The other said, and the other liked that comment. Both of them were sent to jail for this. You want to be careful about how much power you hand over to those who have an inordinate amount of statutory power. And I disagree with you. 90% of the cases cannot be dealt with today's tech. Right. They can probably not be dealt with future tech also, because speech is a hard problem. Those judgments courts struggle with. Eventually, many of them go to the Supreme Court. So please don't bring tech solutionism as a mechanism, especially when there's liability that gets created and safe harbor gets destroyed. Be careful what you wish for over here is what I'm saying.
Thanks, Nikhil. As in, we all understand the limitations of technology, and with multilingual languages, etc., and the technology biases, we all know it is still a long way ahead. But I will bring in Sijo. Chandra, I have seen your hand. Nilanjan, I've seen you. But let me go back to the speakers first, and then I'll come to you.
So I think in terms of bringing perspectives here again, right? See, broadly, I think the Nilanjana's approach involves to say that we need to have a graded approach in terms of assigned responsibility. I think that is the principle I'd also like to say in terms of bringing out these amendments. So even in my opening remark, I said that had some of these more responsibilities applicable to significant social media intermediaries. How do we provision for taking care of that? These are not onerous for smaller companies. So those are areas which we definitely want to advocate from a significant social media intermediary standpoint. How do we solve for this? So that's one. Now, Nikhil, just to quickly respond to you. So I am as much as a private sector person as you can imagine. So yes, at no point I would also, let's say, support a government committee in terms of having an oversight. So even that's not something as a solution. Now, even in my opening address, I was trying to say that even if we have such a utopian situation where the government appointment community starts functioning well, in the present reality, even those orders are not really enforceable, is the problem that I was trying to say as well. So yes, totally alignment with you that the government appointment committee is not the right way to go for it. I was just saying that from an industry standpoint, this deplatforming. So I think in the opening address, one of the either Aman or I think Aman had mentioned that, right? So you might have situations where even government accounts can be deplatformed, and government can't be the judge, jury, and execution in that particular case. In a similar manner, if you look at some of the bigger social media platforms, the kind of power that they enjoy, and then themselves being judge, jury, and executioner, there has to be some limitation of power or some balance of power in terms of favor of other, the level playing field, which Nikhil also mentioned in terms of objective they're looking at. But yes, if you look at, and this is the same thing that sort of happened and which we commented during the e-commerce guidelines also, right? Even when the e-commerce guidelines draft amendments came in, we sort of could see that the intent was to rein in some of the bigger players. But the burden of responsibility might actually end up killing some of the smaller players, and bigger players might be further benefited by having onerous restrictions. So yes, striking a balance is not going to be easy, and that's why I spoke more in terms of principles. If I were to try and strike a balance between Avik and Nikhil, in terms of both perspectives that you brought together, I think the one thing we can only agree is the fact that we are trying to solve for hard problems, right? And we need to figure out a way to solve for it. Technology by itself is not going to be a solution, is what even technologists would agree. And at the same time, just as a note from a thinking of solution perspective, yes, abuse is always some of the examples that you mentioned, Nikhil, is from a civil society rights perspective, and there's also always a politics also behind it, right? Well, so even in the Shreya judgment, I mean the judgment that you mentioned, the principles of safeguarding citizen from the government excess also needs to be honored. So to that extent, yes, principles are what we're talking about. These guidelines are probably a step in the direction of trying to figure out the solutions to some of these hard problems. But from an industry standpoint, do we have a situation where some of these platforms and some of these exemptions that were created at a time where this whole industry was far more nascent, which actually enabled the growth of the internet, as Nikhil rightly said, do we have to relook at some of these provisions, at least in certain graded sections, is a definite question to ask, and we are facing hard problems as well. But from specific to this particular amendments that we're speaking about, a graded approach is absolutely required, not only in terms of serving the intent probably of reining in some of the disproportionate power of some of these platforms enjoy, but also in terms of protecting for our Indian companies and much of the smaller companies. As one more note, monetary fines always comes across as a very simple solution to solve for it. That probably comes top of mind. But monetary solutions are not really, fines are not really a long-term solution. Nikhil himself addressed that. But it again might be the advantage for bigger companies to pay fines, and smaller companies might only want to get a disadvantage. And we're increasingly seeing world over that fines are necessarily not really turning out a deterrent to some of these companies changing their ways. But we are even seeing realities where they are even factoring it as cost of doing business and continuing to continue the process unabated. So how do we create behavioral changes is a bigger question I think all of us are trying to figure out in terms of some of the changes we would like to see. Those are not easier to come by. That I'll close there.
Thanks a lot. So I'll bring in quickly Chandra. Nilanjana, it has to be brief because you've spoken earlier, and Rahul. And then we will go to Aishwarya. Chandra, would you like to speak?
No, madam, no.
Okay, fair enough. Nilanjana, quickly over to you.
I'm okay to skip this round since everything I said was either answered or taken up by Nikhil and Sijo. So okay. Probably in the next thread, I would like to do. Thank you so much.
Over to you.
Sure, thanks, Amrita. Thanks for the wonderful discussions and some very critical points raised. I had a few other points that I wanted to put across. One is that we are seeing further amendments to these IT rules, and still the government hasn't sort of looked at the approach of categorizing intermediaries into multiple segments, which was and which has been in discussions for a very long time, right from the times when the amendments were made in 2011. So one of the things is, as Nikhil also mentioned, that right from starting from ISP to application provider to everyone is covered under one explicit guidelines of intermediary, except creation of a special category of social media intermediary and significant social media intermediary. So one thing is there a scope and a requirement to create multiple segments of intermediaries, because based on the functions they perform, because the reasonable measures and compliance requirements for each of them would vary significantly based on what they do and where they are placed in the entire value chain of the data lifecycle ecosystem. Second, on the appointment of grievance appellate committee, my personal opinion is that I think it's a good experimental step which can be reviewed later. But the fact that this provides an external avenue for settling grievances before hitting courts is because the courts are also overloaded, and if we have multiple sort of these forums wherein these things as an experimental basis. If it works out, great. If it doesn't, then we need to identify like what all things it lacks and how it can improve. So we can have things like these put in place so that we have multiple layers of forums or appellate tribunals or grievance redress forums where these things are handled. My suggestion also is that such committees should be empowered that whatever content takedown request from the government side comes for the platforms, so they should also serve as a level of review or check whether like the requests are properly placed or not, so that we can have an additional layer of independent approach of seeing on what content takedown, what peoples are being asked to deplatform, what accounts are being banned, etc. As given an independent look, and also like that can also be reviewed at an appropriate stage on like whether it is working or not. The third is on establishing rules for content takedown or reducing virality of content classified as terrorism and violent extremism. In certain cases, the intermediaries are expected, and like it's also warranted, that they take immediate action when being notified because of the subsequent harm that can be caused. So if a due process is laid down and if the due process is followed, I would say that even 24 hours for taking down such content should be built, and if it is too stringent, maybe 36 hours, but like we should have stringent timelines, a graded approach. And terrorism and violent extremism, I think, is one of the categories that we need to look at, which is also recognized by Christchurch.
Rahul, we can't hear you. Rahul, we can't hear you. I think he is not available.
Hello, Amrita, am I audible?
Yes, you were inaudible for some time. We heard you till Christchurch.
Okay, sorry, my bad. So, yeah, that was important. That we should also establish procedures for content takedown or reducing virality of certain content in certain manner for terrorism and violent extremism. The next part is on the proposed changes under 3.1b. Task intermediaries shall cause the users of its computer resource. I think this point has been raised also with the minister. But this clearly appears excessive to the functions of intermediary, and generally, if the platforms take measures to cause the users of its consumer computer resource not to host, display, etc., then it will severely impede the free speech and the information processing landscape. And given that as Nikhil was pointing out, the overall direction of not just here in India, but global data governance, it's towards stringent government control. So we need to identify avenues for preserving free speech and making sure that there is less arbitrariness built in the system, plus like the users have more freedom to exercise their voice, and the platforms are not forced to act in a certain direction just to remain compliant. And one last point is, we have always struggled to make companies that are not present in India to be compliant. So how do we make these rules explicit so that the companies that are serving in India physically or digitally but are headquartered outside India, how are they subjected to Indian jurisdiction and comply with Indian laws and rules concerning data and content which is originating from India? It's not to create disparity, but the requirements for companies which are subject to de facto regulations here in India and companies which are headquartered outside are different. So there are also a lot of common elements, but separate elements also need to be created out and explicitly spelled out on how it can be built. Now, this should be done in line with honoring all the international commitments such as under the WTO GATS framework, and what bilateral, multilateral agreements that India has signed. And it should provide a level playing field without actually creating this artificial barrier to entry and operations for organizations. But if we have certain requirements from companies which are India-based and the delta requirements for companies which are not India-based, I think it will give a lot more clarity in terms of operations.
Thanks, Rahul.
So, yeah, I'll stop it. Thank you, Amrita.
Thanks. So I will bring in Aishwarya first, and then Aman, and then Puneet, and Nikhil, I'll go to you. You will end it.
Thanks, Amrita. I see that this has become a conversation about content moderation and what the possibilities and abilities of platforms are, which is, I guess, where a lot of platform regulation ends up. I just think it's useful to contextualize it a little bit in terms of these are important conversations to have, but I think when we're discussing specific rules and lawmaking specifically, I think it's important to think about it more in terms of principles such as speech, which is what we're discussing right now, and incentives and the role of law in creating a system that's equitable and that protects rights such as speech, right? So I think we can all broadly agree that in general, we want companies to protect our speech rights while also taking down bad content. And that means different things to different people. And we just want it to sort of like happen seamlessly. But I think the whole issue at the center of intermediary liability is on who makes the determination of what kind of content is permissible and what isn't. And obviously, we're all cognizant of the fact that technology has moved to an extent that it's not possible for a court to make a determination of every single piece of content that is available online, which is why technology is already used to make large kinds of determinations. It's only these kind of edge cases that usually end up being what is most interesting, but also what is very difficult to assess. So one is whether we want platforms to be making these kind of assessments. And two is with the regulatory landscape that the rules impose, where you're threatening safe harbor, where you, for platforms allowing the upload of a wide range of content, what are the kind of incentives you're putting in place? And what kind of speech will be allowed on platforms, right? So thinking about it in broader terms might be more useful, especially in terms of like regulatory and sort of law forming. And to bring it back to that, maybe this is again like more a legal point, but the rules aren't necessarily the place to address the issue of intermediary liability. If you do want to shift that standard, that's a separate conversation to have at a legislative sort of phase. So if you want to amend the IT Act and then you think that that's a separate conversation to have, but specifically about the proposed amendments to these rules, it's not necessarily the best place to sort of directly target the way that the model, the intermediary liability model currently works. And also, again, I know that the government has sort of, in the introduction to these rules, sort of mentioned self-regulation and the fact that it hasn't really worked in this space. But again, we haven't really tried it in this space. We've tried it for online OTT platforms. It hasn't really been attempted in any sort of significant way for social media platforms with respect to speech, which is what ostensibly all of this applies to. And so it's always better when it comes to speech harms, because you're restricting speech as the consequence of sort of a more prescriptive approach. It's better to sort of shift to that, to shift to a more prescriptive approach based on how things are going, rather than sort of imposing really onerous obligations that treat platforms as publishers pretty much. So yeah, those are pretty much my thoughts.
Thanks a lot. Aman, I'll come to you for your last comments.
Thanks. I'm actually going to try keeping this very short, also not wearing my lawyer hat for this, but maybe as a sort of user of the internet and someone concerned about what I'm able to say and not say. And I think just one of the points that's been made even on chat is, finding that sort of shift in power between platforms and between the government and us as users in the middle. How do we achieve that? And I think really, I mean, it might have been said many times before, but transparency is really what we need to achieve that, right? Transparency in terms of how platforms are making decisions. I think sometimes there is a lack of transparency there, and two, on how the government is also exercising its powers in terms of takedowns, etc. I mean, just referring back to Shreya Singhal, even 69A was part of the challenge there, and the court said, you know what, there are enough checks and balances within how that framework is set up. I think that needs a relook, because there is confidentiality obligations. Puneet maybe touched that point, that where there's national security, it might be justified. But again, that can be timed, right? It's like 3 years later, we should at least be able to look back and ask those questions as to why was something taken down, or why was a particular app banned entirely in the country. Those are questions that we should be able to ask, not just platforms, but also the government. And I tend to agree with a fair bit of what Nikhil said in terms of the ability of, I don't think I agree with that tech has the solution to everything. Speech is a very hard problem to solve. I think these are things we're looking at all over the world. It is essentially boiling down to this question of where do we want this power to be? And I tend to agree that users need to have a lot more power in this entire equation. And one of the ways of achieving that is having a lot more transparency on both sides. And I will pause there and not really go more into what needs to be done with these rules, etc. I don't think a little bit of the pessimism is there, but I do think we should all at least submit our comments, try making our points, because no point giving up that just yet.
Yeah, thanks, Aman. Puneet, your last points.
Thanks, Amrita. And there's been a long and rich discussion here, so I'll keep my remarks brief. Just 2 quick points to sum at least my reflections from this conversation. And I want to emphasize here that I'm speaking in my personal capacity. One thing that we need to focus on, and I think Nikhil touched upon this, is not just what the regulation is, but how we arrive at these regulations, especially on intermediary regulation and now in an increasing sort of range of issues that in the tech sphere. There are consultations being held. There are rules coming out, but we don't always necessarily know the rationale for why a particular rule has come out. This is not debated the same way or at the same level of sophistication that we see in many other domains. Like, for instance, with TRI regulations, for instance, there's an entire consultation paper, right, where TRI comes out with its justifications, proposes ideas, and you might not always agree with sort of the ends and aims of the final regulation that comes out, but there is a sort of more informed basis for discussion around those regulations. With the intermediary guidelines, again, there's been a back and forth going on for a long time. There was a consultation in 2017, 2018, and we see that a lot of the things that were pushed back against back then are finding their form back now. And there is at least a very sort of command control type of regulations that's continuing to occur. And especially on the internet, especially given the architecture of the internet, I don't know that form of regulation is efficient, is the best way of solving problems. And finally, of course, as lawyers, it sort of does what it meets the standards that are expected both in the statute and the constitution. And we're seeing that play out in the context of the IT Act, the intermediary guidelines, data protection, the list goes on. Second, and this keeps coming up a lot, at least in the last 5 or 6 years, there is a lot of regulatory arbitrage that players in the tech space see between big companies, small companies, Indian companies, foreign companies. That's fair and good in many other areas. There are merits to arguments on both sides, but when it comes to the intermediary guidelines, when it comes to issues of free speech, I think they're agnostic to both sides. They're agnostic to where you're from, because it deals with, and as we're seeing now, issues of free speech, issues of constitutionality and things like that. There's a reason these issues get litigated over and over again, because this is not an easy problem to solve, as many other panelists have pointed out. That's it from me.
Thanks a lot, Puneet. Nikhil, you have the last words.
Thanks, Amrita. So I just wanted to remind everyone of a little nuance to the IT Act regarding intermediary guidelines, and this is in response to what Rahul had said about different functions and essentially vertical regulation coming in. Intermediary, by definition, is a function. It's not a type of company. And which means that a publisher like us can have a comment section, and for the purpose of the comment section, we're an intermediary, and for the purpose of publishing, we're a publisher, right? So structurally, let's not confuse the two. The vagueness or the breadth of the phrase intermediary allows for innovation and shape-shifting, which means an iBibo, which launched in 2006 as a blogging platform, then became a social network, then became a music streaming service, then became a gaming service before it became GoIBibo, which was a travel company. All of this innovation and shape shifting, or even Ashish trying to find a business model with that business, was allowed because imagine the kind of regulatory shifts that a company will have to take if vertical regulation comes in. It's going to be, everyone's going to be stuck with one business model. And we don't want to lose that flexibility in the internet, right? Lastly, and I'm sorry, I got a little pissed off about this particular comment, but really, if the government wants to take down Facebook and Twitter, and Facebook is, for all practical purposes, no angel here, bring on a regulation that does that. If they want to benefit coup, which, at least going by the comments here, seems to be in favor of a regressive regulation that's going to hurt our constitutional right to free speech and effectively harm civil liberties. If they want to, support these regressive regulations for their own business purposes because they want to, harm foreign competition. If the government wants to enable an environment where foreign players are hurt, then bring out a law that goes after foreign companies. Let's not go after free speech, and let's not create a regressive environment for free speech for everyone. If the objective is to go after foreign players, do it. Do it overtly. Why is this covert approach? I think we're creating a really, really bad environment for business in this country, for startups, for speech, with this kind of a regressive approach from regulation. And it really doesn't help that Indian companies and folks are trying to use this to benefit themselves and Indian companies versus a global environment. We've all benefited from a global internet. I think we don't want to, unless you want to become a China, which is where we seem to be headed towards, in terms of many regulations that are coming in, and there is overt government control over how business functions. I think we need to keep an eye on how this impact our access to a global internet, our ability to engage with the global internet. And I'm not talking about big tech platforms. Leave them aside. There is an internet that all of us have grown up with outside of that, and we don't want to lose that environment.
Right. Thanks, Nikhil. I think the minister also in his communication said, and even in the press note, that we want an open internet, free and trusted. So we hope for that. I think we may have divergent views within the room on many aspects, but I guess some of the common threads are: we want accountability, we want transparency, accountability from companies, accountability even from the government. Even the government needs to be transparent in terms of how they are exercising their power, how legitimate it is, and also there should be a reduction in the arbitrariness, which is currently prevalent. These are certain things which we kind of agree upon. Rahul, I can just give you 1 minute and then I will have to close it.
No, I won't take even a minute, but I completely agree with Nikhil that this intermediaries is based on function, what makes you an intermediary. But I do not agree with the point that vertical specific regulations impede on.
Rahul, we are unable to hear you now.
I think he's trying to say that vertical regulations don't impinge on innovation. You have to have run a business that has had to transform rapidly to be able to know how that works.
I will cut off this conversation now. And Rahul, sorry, we can't hear you. But thank you all, everyone, for coming and participating.
Hello, Amrita?
Rahul, I'm cutting you off.
Okay, that's okay. No, just I wanted to make just 10 seconds, but I'm saying that, the vertical specific regulations, I disagree that, they do not impede on innovation. If a company wants to switch shape and form and enter into a different field, they will have to, comply with different regulations, which are vertical specific. So I don't think vertical specific regulations are meant to curb innovation. By process, by design, they can. But our efforts should be.
The point is, they will have that impact, because you'll have to keep complying with a different set of regulators. You have to dismantle what you're doing.
Cut it off.
When you run business, you know how to keep complying with different regulators, how difficult it is. And that's what the internet has enabled.
I will have to cut you off now. Thank you so much. You can take it offline, this discussion, but thank you everyone for participating. Please put in your views. And this is the kind of, there are various nuances and layers to it. There is no right or wrong. We are in gray area in this kind of a situation, wherein we may want to achieve something, but we may harm something. So we need to be cautious and at least try our level best to give our comments by the 6th. So thank you so much, everyone, the speakers, Nikhil, Sijo, Aishwarya, Puneet, Aman. I think Aman has left. So thank you, everyone.
Thank you.
Thanks, Amrita.
Thank you.
Thanks, Amrita.
Thanks, everyone.